wonderful alumni on our parental staff. Our top, okay, next slide. The topics we are hoping to cover today, and by hoping I mean hope to get through all our materials. We understand you're an exciting and lively bunch and are looking forward to interesting questions. Are just a brief IP overview, which a number of the materials may be familiar to some of you, but that way we'll all be on the same page. And then getting on to what we consider the top 10 hot, interesting IP issues to consider as you're going through your IP practice, following by some more current topics in case law and legislative and administrative activities that we find particularly interesting that are getting more active right now.
So the source of intellectual property, I'm sure most of you know, but it does come right from the U.S. Constitution, Article 1, Section 8, Clause 8. That is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This was a great thing. It set into motion that the advancement of technology would be shared, would be open, and be patents laid open. And when trademarks and copyrights, it really advanced the arts. It helped develop what we are now enjoying today in the technologies and the creative sides, the commerce. So it all stems back to the U.S. Constitution. And from that, the laws and then the different rules and all that. So the obtaining IP rights, you're probably all familiar with this too, but just to be sure. What we have on the top row there is the U.S. Patent and Trademark Office down in Alexandria, Virginia. And if you were to apply for a patent or trademark, you would go ahead and submit your documents to that organization. Just to get a sense, have people in this room participated in that process at all? Raise hands. So a little bit know about, some of you know about this, but a lot of it is done online these days. You can do electronic filings. On the trademark side, your trademark's going to publish day of, and on the patent side, as you may know, you have 18 months for publication to occur. But you see, so at the end of the process, you might get something on the right side up there, which is an issued patent. And those of you who have held in your hand, you'll see that, you know, there's a ribbon. There's really, it looks just like what you see up there. There's a gold seal and a ribbon. And actually, it's a very nice document. It's a very formal published document. So it gives you some honor when you do receive one of these documents. You want to do the work? Okay. So I'll handle the world here too. And so if you want to say, well, I really do want more rights than just the U.S., right? So then you want to say, I want rights up in Canada, I want rights in Europe, I want rights in China or Japan. You might use a process that's called the Patent Cooperation Treaty. Patent Cooperation Treaty is an organization that, well, it's not an organization, that's a treaty where countries around the world say, we're part of this treaty. So what happens is you can have a centralized filing. You can take your U.S. application as a priority document or file directly via the PCT. And you file an application and you get examination reports. And based on those examination reports, or despite those examination reports, you can say, okay, we are going to file in Europe, we are going to file for protection in Canada, Australia, around the world. And most countries are part of this. There are some countries still that are not part of the Patent Cooperation Treaty, so you may have to file separately. But eventually you'll get the centralized activity happen via the PCT, Patent Cooperation Treaty, and later, within 30 months typically, you will be required to file for, on the patent side, that protection. So you say, I want to get some rights in certain countries or regions such as Europe, and the process continues from there. So there will be reports via the PCT examination. You can respond to a report and get a second report that tells you how well you did, and then you can enter the different countries. And each of those countries has their own activities. So you will have to then go through some examination process. Depending on what you hear via the PCT report, you may have a protracted examination process through these countries, or you may have a very quick examination process through these other countries. So there can be a lot that you learn via the PCT, also documents that may have to filter back to the U.S., references that you have to submit to the U.S. Patent and Trademark Office, and a report from the International Searching Authority. So there's a lot here, but the basic idea from this chart is just to say we do things in the U.S., and then there's also some activity that can go on internationally. And just so you know that if you're registered in the United States, you're not registered to practice before the patent offices of other countries, so oftentimes you'll link up with other firms from around the world. So, we have to work with practitioners from around the world, so there's oftentimes a lot of communication and, different activities that happen. I know I've gotten Paul involved with, some of these activities, so it does happen quite frequently whenever clients are interested in international protection. Then it starts a long process for that. So that's a little bit of the overview, and just thought, just to be sure everyone's aware, U.S. and international, some differences there. So, and just by the way, protection in the U.S. doesn't get you protection in other countries. It really is territorial.
So as you know, a patent is a piece of property, and one of the important values to have a patent is that you can have a limited right to exclude others from using your intellectual property without your permission in your limited circumstances. And one of the most interesting parts of our practice is patent litigation, which is primarily, in most cases, the enforcement of patent rights. There's other types of patent litigation as well, and of course there's trademark litigation as well. But the predominant litigation we do is either as a plaintiff, where our client owns the patent and wants to prevent someone else from making, using, selling, importing, etc., or offering for sale the patented subject matter without their permission or license. Or being a defendant. They've just gotten a nasty gram, as we call them, letter in the mail saying, you should be aware that we have a patent on this technology, and you are infringing it. And then you go to court, and then you try to enforce your rights if you can't work it out, ideally without the lawyers, but it often comes to us, and work out some kind of a deal. We generally start out in district court. There's our beautiful building that we built a few years ago in downtown Boston, where our Boston Patent Law Association dinners are usually held, with this beautiful view. And then whatever side loses generally is not happy and appeals to the appeal court. And in 1982, we developed the Federal Circuit Appeal Court, which is a specialized appeal court. For any other kind of case, just about any other kind of case, you would go to the appeal court for your region. But what they decided prior to 1982 was, let's make a special court that's specialized to hear just a few federal questions. I think there's some admiralty law that's heard there, some maritime law that's heard there, and they hear the patent cases. It's very interesting to go down and participate in a federal circuit hearing, because you'll see the docket for each day. You go in the morning and you try to see which judges are you getting. They don't announce what judges you're going to be heard before until you actually go there in the morning. So all the eager litigators wait in the morning, and the list goes out that you're going to be in front of Judge Rader and Judge whoever, Garza, and you're like, yes sir, no, or shoot, because you already looked at the prior law, and you're like, oh no, I know Pauline Newman hates this kind of law. This is not what you do for me. We used to do these charts where we would take all the judges that could possibly be hearing the case and see where they were coming out on all the major prior cases, how we would tailor the oral argument based on that. But that's it. But then you'll sit through other cases, and there'll be a lot of, to me, because it's not my field, obscure admiralty and maritime law cases as well. But it's very interesting. And then from there, you have, let's say you lose there, you're still not happy. There's two things that you can do. One thing is you can do a petition for rehearing en banc. And what that means is you're going in front of just 3 judges on the circuit. And so there might be different 3 judges that might have gone another way. Like I said, you sort of don't know till that day. It's possible that if you've gotten 3 other judges involved, maybe you would have gotten a different result. So you try to say that there was petition to say, I want this case to be heard before all the federal circuit judges. That's what to me meant by en banc. But they don't have to do that as a matter of right. They decide whether they're going to hear that case, because otherwise everybody would do that. They hear it in front of the three judges, and whoever lost would say, okay, I want to be heard in front of everybody because I lost, I want another shot. So they only hear certain cases. But it's very interesting when they're all there. I did an en banc case, and they're all lined up, and everyone can ask a question, and it gets very lively. And then from there, as you know, you can go to the Supreme Court, but obviously everybody would want to go to the Supreme Court. So the Supreme Court only chooses, you have to actually request to be heard by petitioning for certiorari, and they're only going to grant certiorari in certain cases, and not all that many patent cases. So when a patent case does come up to be heard by the Supreme Court, it's a very big deal for all patent practitioners. They get very excited because it's not very common, and we all get all worked up and jazzed. So that's the case there. So it's a very interesting process. And of course, each time they can punt it down to be remanded, which the appeal level court can say, we want you to reconsider if the court will over reconsider based on certain instructions and facts.
Okay, so we're going to now move on to the top 10 issues and strategies. As we go through this, feel free to ask questions. This is meant to be a dialogue. So, we'll raise the issues and give possibly some examples that we've been involved with. But if others have questions or have been or comments or have been through these similar situations, feel free to bring it up and we can share it with the group. So these are the top 10 issues that we've identified over time that we like to talk about. And we'll go through each one individually with a few examples here. So we're just going to briefly cover this because I know there are some other speakers this afternoon, but there are copyrights, trademarks, trade secrets, patents, are forms of IP that can build assets. So oftentimes you'll have clients who say, I have this situation. This just happened to me just this past week. We have software. We're thinking, would it be a good idea to copyright our software? Should we patent the software? Should we try to hold on to it as a trade secret? These are questions that practitioners will receive over the phone from potential clients, existing clients, clients who, they're getting into a new business area. And they're saying, what should we do? How do we protect it? How do we, we have limited funds. Is there something we can do based on what we do have available to spend? So, so these are issues, but that build assets. Intellectual property is property. You can use the property later if a business is going to be sold. So clients say, well, we plan to sell within the next few years. We're trying to sell our company. We're trying to joint develop. So these are issues that come up. So just briefly, those of you who have been through a survey course or taken an in-depth course might know that copyrights, original work of authorship that has been fixed in any tangible medium of expression. So books, obviously, songs, videos. Any other examples?
Even a medical form, even the way things are laid out in an envelope can be all kinds of fixed expression.
Websites, right? So you start to think a little outside the box, pantomimes. The other expressions. Trademarks, exclusive rights to use marks that distinguish one company's goods from the services or products of another. So examples here might be the Coca-Cola symbol, Nike swish. Anyone else?
Sound trademarks at the beginning of movies, maybe?
Yeah, good.
What about like perfume?
Scents, yeah. Yeah.
Sound of a motorcycle.
Yeah.
Yeah.
That's a Harley
That
Davidson.
was a famous piece.
Yeah.
CNN. I think
Yeah.
CNN one.
Okay.
The pink color of the pink, that insulation.
So any source indicators, so these can be strong, right? So copyrights have a fixed duration, 70 years the life of the author plus 70 years, and there are some exceptions if it's a work for hire. Trademarks can go on indefinitely. So as long as they continue to be used as a trademark, there are certain obligations you have to be careful of. The speakers this afternoon cover that. And
Trade secret.
trade secrets.
Now, the trade secrets protect secret business information. It's confidential, and it's often a state law matter. And as it says here, it protects secret business information against unauthorized use. What a take-home message as your future practitioners, I'd like to say, is when you get the potential of a patent case, somebody comes to you and they want you to either create or protect or enforce patent rights, you really want to do a good job for them. You should be trying to protect their whole business. So you should ask questions. When they send me material, I say, oh, I see you're using a logo here, using your name there. Are you considering trademarks? Are you considering whether this is protected as a trademark? That's something you need to consider. You have some material here that looks like it could be potentially copyrighted. Have you considered those? I think as a good holistic practitioner, you want to at least ask those questions. And even if you're a straight patent lawyer, they often expect you to know those answers. So you should have at least a general sense of the questions to ask. Now, whereas copyrights and trademarks and patents can all protect different aspects of the inventive and creative materials of your client, whether it's your in-house client or you're an outside counsel. Trade secret, on the other hand, can be protecting exactly the same information and invention as a patent. So in that case, it can be an either-or situation. You can have a trademark and a copyright and a patent on similar technologies, all touching a different aspect of it. But trade secret versus patent, that's a choice you want to make. Do you want to keep something does your client want to keep something as a trade secret, or do they want to patent it? And when you become a patent lawyer, you get very gung-ho about what's good about patents. But patents aren't right for everybody, and you want to establish credibility, and you want to do a good job and be trusted, and not just go for the big money and get the patent for the client. You want to make sure they understand the advantages of getting a patent and the disadvantages of getting a patent. It may be very valuable for them with their business model to not go for a patent in a particular situation, but to protect it as a trade secret. You'll have their trust in their credibility, and then when they have something that is more appropriate to patent, then they'll know that you're trustworthy, that you'll give them the right advice. So they want to consider, maybe a patent is going to be published. It's going to be published, the patent application is going to be published. So they may be divulging all the secret, special aspects of their invention. They may never even get a patent. They may want to keep it confidential. Patents are expensive. A small company may not be able to afford it. So there's different things to consider. They may have run out of time. They might have time considerations and place considerations. So one important aspect is to make sure you understand the trade secret laws in a region that would be affected for your client, and what is the best decision, whether they should be going through the time and expense, in which case you'll do a great job and get them a terrific patent, or whether in certain cases for their business goals, it might be more appropriate for them to go the trade secret route. I came in late on a case recently where there was a big problem. There was bad data had come up later after the patent had been filed, and the data showed that for this medical situation, it didn't necessarily work for certain, the compound in question didn't necessarily work for what it had been patented for. And I stepped in, we were going back and forth about how to meet your proper duty of disclosure to the patent office and divulge the information so that you're not doing anything fraudulent and that you'll get an enforceable patent and what to do. We were going back and forth, and they realized that they could get this very narrow claim that maybe they wouldn't have to divulge the bad information because it's such a completely different claim. And I just said, I was new to the case. I said, was that going to have any value to you then? You didn't do any clinical studies at all on it. You didn't do any research at all on it. So you don't have any bad data, but then you get a patent to that. And how would that meet your business goals? And they sort of scratched their heads and they realized they hadn't managed to come up with such a narrow claim. It had no business goals. It was going to be all this money and all this time to get this really narrow claim to this particular technology, and it was going to have no value to their business goals. So you always have to keep in mind, what are the business goals? What are you trying to do? Are you going to be manufacturing this drug? Are you going to just be using it as a shield to prevent your competitors from manufacturing it? Maybe you're a tiny little company, you're a startup, there's only 2 of you, and it's very important to be attractive to your investors. And if you just really kind of want to get patent protection on what you can get patent protection on, it shows that you're taking your IP seriously, it shows investors that you know what you're doing, and maybe you don't know yet if you're going to be able to use license it or manufacture it. But so patents have different values, and you just want to always make sure through every step of your decision-making process that you're really meeting the business goals and not just getting a patent for the sake of getting a patent if it's not going to meet the business objectives, their client.
And another thing about the trade secrets is this will go on indefinitely, provided you can keep the trade secret a trade secret. So the formula for Coca-Cola, although there are some claims that it was recently published, it's still really, that's not accurate. It's still a trade secret. So it can be a very strong form of protection. There are cases all the time, litigation on trade secrets. These can be millions of dollars worth of value. One thing you have to realize is, yeah, you really do have to protect it. If it's a formula, maybe only one person in the company knows the entire formula. It's kept in a vault, and other people only can make a recipe up to a certain point, and then it moves to the next person. So even within the company, it isn't widely known. And I would, if you're working with vendors on such things, maybe you can't keep it a trade secret. In the case of the software I mentioned before, I said, well, you have a very migratory business. It's possible somebody, if it could be reverse engineered software. It might be that patents are your better way to handle this, unless you could keep a kernel portion of the software as a trade secret, and maybe patent things, different inventions around that kernel, keeping that kernel very, closely held. But it is very difficult in certain sciences and technologies to hold on to trade secrets.
As we discussed a little bit, a patent is basically a deal, a contract with the government in exchange for a limited right to exclude others from making and using or selling, etc. your invention. You as an inventor get if you provide with the government with a written description on how to make and use your invention, you get this limited monopoly, which can confer many high advantages, as we discussed briefly, and it can be very worth it, and it can get you $1 billion settlement if you get a wonderful pioneering patent that becomes very important in the industry. So you can license it, you can sell it, you can use it as a negotiating tool. A lot of times my clients get a patent, not so much that they plan to use it, but they know someone else, they know that their competitor in the business is going to want to use it, and they want to use some of the competitors' patents, and they say, we'll license our technology to them, they'll cross-license their technology to them. So there's many uses, cross-licensing, licensing, owning, and enforcing, keeping others out of the industry, and all kinds of different things. So it can be a very valuable, obviously it's a limited monopoly, and an important thing to keep in mind, as you probably already know, a patent, what does a patent not confer? One right it does not confer is the right to use the invention. It confers the rights to keep other people from using the invention. It does not give you any rights to use your own invention. Why? Because maybe somebody earlier had a broader patent, and you've come up with a narrower, specific aspect of the device or narrow way to make or use a method. But a patent certainly does not give you any rights to use it because there might be a patent in you. But maybe you can cross-license with the owner of that broader patent so that they can use your special new improvement or your special new aspect, and you can use their general patent.
So every so often, clients will say, well, I can't afford to get a patent. How do I make sure that no one else gets a patent on this technology? And the simple answer is publish. Go ahead and publish it. You won't get a patent, but neither will anybody else, depending on certain factors, but at least if no one had filed prior to the publication, they won't be able to come later and obtain patent rights, which may not be valid, but it would cost your client a lot of money to go to court to invalidate this other party's patent. So one way, a very inexpensive way to just be sure that your own client can continue to practice their technology is go ahead and publish it. But you are foregoing rights, so you really have to think hard about whether or not that the client is really interested in that, but it is an option. And as Deirdre's been mentioning, all this comes back to business. How do you use this intellectual property to the best advantage, economic advantage or otherwise? So those are some issues to think about.
That is an excellent and creative way to keep some somebody, a good way to show that you're not just thinking patent, 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 but what's really best, that publication may be the least expensive way. That said, my patent practice is on the biotech pharmaceutical side. I think this may be even more true on our side than on the electrical side. Almost inevitably, the worst prior art, meaning publications, et cetera, that are cited by the patent office as rendering our claimed invention potentially not novel, is publications by our inventors that always, she's nodding because she knows, inevitably, I get this wonderful new treatment for cancer application, and there's data, and there's mouse data, there's great data, there's clinical data, oh, it's great. And we file the patent application, and the inventor's like, oops, here's the publication, that abstract that has been published. This is a paper that we gave at an Oregon Talk conference, et cetera. And I'm constantly contending with papers and publications by my own inventors, which are really good at teaching what's claimed, because it's the same people. So it's the way they would enable the invention is pretty much right there. And it's we can't really, it's not easy to denigrate, because it's, again, often the data that the patent application is based on. Also earlier patent applications are often the worst prior art. So that will go more as we discuss to getting the patent application filed in a timely fashion. But just be careful, if you publish as a means to block others, realize that you're blocking yourself as well. Basically now, the next thing we wanted to talk about is the timeline for getting a patent. Again, thinking of the business and practical objectives. We'll go into this in more detail, but basically, the inventors conceive of the invention, you file the invention either United States or abroad, or you file your provisional application first in the United States, etc. Then it gets examined, which is your back and forth conversation with the patent office, where they say, you say these claims are great, and they say, no, they're all terrible, I reject them all, and you go back and forth in a process of you amending your claims and making arguments to show the patent office that yes, you do have a patentable, novel, anticipated, well-supported invention, and you develop this dialogue with the patent examiner where they say, well, we're concerned about this, and then you amend your claims to address that, or you discuss with the patent examiner's ways to overcome it. Until finally you convince the examiner, you've reached agreement, you've negotiated a patent application with claims that the examiner is comfortable, are novel and new and wonderfully supported, and your client feels have good value and seems like a reasonable position, and the case gets allowed. Then, again, more fees, it's always more fees. And then the patent grants, and then there's the post-grant activities of paying the maintenance fees every few years to keep the patent going, and then deciding whether you're going to, theoretically, you have filed some continuing daughter applications to proceed with.
So this is a little bit more detail on that timeline. And so you can see that at the very top it's a conception. The inventors or inventor says, oh, I have a new widget. I think I can build a better mousetrap. New technology in some form, maybe evolutionary, maybe revolutionary, but comes up with an idea and says, well, maybe this is patentable, and of course, seeks out advice and says, well, what should I do with this? And then, of course, it's that other activity, right? Do I patent? Do I trade secret? How do I commercialize this? How do I turn this into value? And then, so you might come up and have what's called an invention disclosure meeting, where oftentimes one or two attorneys will sit with the inventor or a group of inventors and say, let's hear what you have to say. So, you might ask 3 questions, which is, what is the problem you're solving? How are others solving it? And then how are you solving it? And through that conversation, you get to see a picture of what the invention is relative to the prior art. And it's that difference that you can then determine the scope of what is novel. And you also want to go through and figure out, why is this not obvious given the prior art? Those of you who have heard about the 2007 case, the KSR case, it was a Supreme Court case. If you haven't read it, it's a good read. That the Supreme Court said, well, obviousness you should have a broader interpretation than the way that the Patent Office has been treating it. And so, oftentimes in the invention disclosure meeting, we pick out certain examples, right? Well, you say this is the closest prior, but really, listen, I have my own computer at home. I've got certain technology. I think I've seen something like this. So why do you really different? I mean, why wasn't it obvious? You show a list here. You do some sort of calculation, but it's sort of obvious that the person of ordinary creativity trying to solve your problem may have come up with it. But that's the part of the invention disclosure meeting, and in a little while we'll show some examples of claims that would have come out of one of these invention disclosure meetings. So you come out, you say, okay, well, here's what we're going to, here are the claims. This is what we define as the invention. And based on that claim set, that's the outline for your patent application. And in the electromechanical soft drawings, we're going to have some diagrams that support the claims, that illustrate those claims diagrammatically. And then there's a specification, and all that gets written up and iteration, you and the inventors, and you turn it into a patent application. And usually on the electrical software side, maybe it's 15 pages. On the life sciences, so pharmaceutical sides, couple hundred pages. And
that's before the sequence.
before the so you get a sense, how much is in it. So, maybe oftentimes I'll have like 15, 30 pages worth of text, and then a bunch of figures. And it could be more. I've had up to 100 or so pages worth of application. So it does depend on the technology, the scope of the claims, how many inventions you're putting into one application. There are a lot of factors. No two applications are ever alike. So you'll go to the filing process. So that sets up certain time frames. So you file an application, let's say you file in the US, or you can, there's provisional and non-provisional, but let's just assume you filed an application. You'll have a year within which you have to make a decision. You're going to foreign file. If it was a provisional application, you also have a year within which you have to file a non-provisional application in order to claim the benefit of that earlier filing date. So you'll choose that time frame, and then over a next course of time, you'll receive what are called official actions. You may get examination reports. Hey, the patent office says you have more than one invention in here, and you say, yeah, okay, you're right, and you'll have to choose one set of claims to prosecute. And you'll have to, maybe get substantive examinations. So it says, hey, I see this prior art. What do you have to say? Why are you different and not obvious? In view of that prior art, well, there may be some other procedural things, some cleanup work. Not a big deal. Then you go to the publication. In 2001, the U.S. adopted the international standard, which was 18 months after the priority date. The patent application is going to publish or be laid open to the public, right? That's your exchange with the government. We're going to, in exchange for providing the technology to the public, it's going to publish that you may get certain rights, right? Patented rights. So you have the publication, and publications can now, they can be used as prior art. So an earlier patent publication, even though it's not an issued patent, could be prior art to your own patent application. So course happens, you go through the examination process, official action, what we call it prosecution, average a little greater than 2 years generally for that entire process to take place. I have some that have issued sooner than that. I have some that are still pending or maybe on appeal 10 years later. So it does happen that it can take a long time. So you got to be careful, give reasonable expectations to clients, realize there are always delays, the patent office, maybe your own side, maybe you have to do some procedural activities, but it can take a while. You'll end up, hopefully at some point, gaining an allowance, and then you have to make a decision. Do you want to keep opportunities open? Keep your options open by filing a continuation application, a divisional application, all those activities. So at a certain point, then your patent should issue a grant, and then there is a short time frame after that, a re-examination, reissue if you want to broaden the scope. Not a good procedure. You're better off maintaining pendency through a continuation application. And then there are always maintenance fees. In the U.S., it's 3.5, 7.5, 11.5 years. Those are basically taxes to the government. And internationally, you've got to be aware, every year you may have to pay what's called an annuity. You pay the foreign patent office is the government's an annuity for the sake of keeping your application alive or your issued patent alive. A lot of European countries, every year, you don't have an issued patent, but you're still paying. So be a little careful and give clients expectations, because the cash flow, you choose a lot of countries, they're going to need a lot of cash flow, especially internationally. But this is sort of that life cycle for trying to obtain the patent protection and what happens after.
And about the maintenance fees, as a patent prosecutor, I always consider them sort of wily and irritating, additional expense. They keep getting you, and you've spent all this money, and they're still getting you every few years. You have to give more money to the government. But I now sort of, in addition, see it as both a positive public policy, because if a client realizes 7.5, 11.5 years later they have zero interest in the technology that they patented, by not paying the maintenance fees, the patent expires and allows the public to use it. And I think that's got a value in itself, because you're no longer maintaining a monopoly over something you care nothing about. In addition, as a litigator, one's first step upon getting a new case, if one is defending someone who's been accused of patent infringement, is to quickly go check to make sure the maintenance fees are paid up, because if they're not, you have an easy initial motion to dismiss. A lot of times people don't think to check their maintenance fees. They just, due to the nature of their bookkeeping practices, they're not used to having patents, and they just don't keep up on it. So they'll accuse someone of infringing a patent, and they don't realize their own maintenance fee is expired. There is a little grace period in there, so you want to be careful when you attack, when you strike back with your motion to dismiss for failure to pay maintenance fees, because you don't do it in a period of time that they could quickly pay it in time. So that could be a valuable thing. So the maintenance fee issue can help and hurt. And follow up on what Mark's comment about foreign annuities. In some countries, the annuities start while you're still prosecuting the application. So if you have a patent, you're paying like a regular large amount of money.
Yeah.
And in Europe, if you file a continuation, you have to pay all the past ones up to the date. It's this huge initial expense.
Right. So these are issues that you have to worry about. Just have some relative numbers. In the U.S., 3.5, 7.5, 11.5 years correspond to, I think it's a little over $1,000 for that 3.5 year large entity. $2,500 or so for the 7.5 years, and over $4,000 for that 11.5 years. So it gets progressively expensive, but after you've paid that third one, you have the patent is going to be maintained all the way through that 20-term lifespan with whatever adjustment period is part of that. So you just get through these, but you can see that there are some real costs, and internationally, such as Europe, it starts at maybe $600 and seems to add a few $100s every year that you want to keep it in force. And as Deirdre said, you file a divisional application, you're going to bring it all in, and generally you're looking plus the filing fees, and you might be looking at $12,000 to $15,000 for some applications, and that's before the attorney time.
Yeah, incredible. So, I always tell people, especially new patent agents and attorneys and practitioners, you wear 3 hats at once. So as it says, it's a very intellectually complex job, because you're always wearing your science hat, your law hat, and your business hat. And you have to, and each of those hats might lead you to a different consideration. What is legally possible? Do we think we can get a patent on this? What is technically possible? Is this an operable invention? And what is makes good business sense? So you sort of need to always be thinking of all 3 of those with every decision point. And everything on here is a decision point, including all of these. Just as it's a business decision, your client should be considering before you pay each of these maintenance fees. Are we still using this technology? Should we let this one go and use that patent budget for a new patent application instead of maintaining this old one that's maybe old technology by now, or you couldn't get FDA approval or whatever. So everything should be considered not just an automatic. I mean, some clients who are very large and don't have they just want you to just keep everything alive until they tell you otherwise, and that's great. Those are very easy clients in that respect. They just say keep everything alive unless you tell us otherwise, and you just go pay. But for some clients, you want to help them out by saying, do you really want to keep going with this? Is this your best use? We're happy to do it, or we can let this one go if you're not using it and use the money in a different case, etc. So there's ways to control patent costs and fulfill business objectives by letting go of technology patents you don't no longer leave and putting that money into new patent applications. which by the way is fair of you because that goes to your fees rather than these, which are straight patent office fees. Next slide. This is actually one of my favorite subjects. I give talks on a whole talk on just this because it's so important. How to, and I've also done radio shows on just this topic. It's that important. So it seems housekeeping, but it's as important as a picketing, particularly under our current United States system, as we're still a first to invent system. We're probably all familiar with the Potential Patent Reform Act that might change that to harmonize us with other countries. But right now we're a first to invent system. Whoever invents it first and can prove they invented it first wins. So the most important part of a company's materials and property may be their inventor's notebooks. Now I say notebooks because nowadays everything is often computerized, but we talk about notebooks because a lot of stuff is still done on notebooks. What is this about? It's about protecting your idea, showing you were first, and also getting all that data in while you have it. You might think your inventors are great, but they may leave on very bad terms with your client, and then you're screwed if you don't have good records, because now they're gone, they're going to work for the company, and they want nothing more to do to help out. So you really want to get, not just to prove your early estate, but to show that you have fully enabled the invention, every bit of information. So should they go the notebook route? Well, I usually bring one. Does anybody have a kind of notebook that doesn't have a 3-ring binder in it? That's just like a solid, like a black and white, marbled or anything like that? You see something like that? Okay, so something like that. What you really want is a notebook that you can't put pages into and out of. You don't want binders. You remember when you're a little kid, you have the kind of the black and white marbled front that you can't, if you take a page out, you can't add a page in. Those are what is often used as traditional inventor notebooks. The most old-fashioned kind you can get, that you can put no clips, no spiral, nothing like that. Spirals are terrible because that's hard to add a page to as well and make it look like it was always there. But something really tightly bound, because what you really want to show is the best evidence you can show that somebody didn't after the fact try to change something. So how do you do that? You want everything in ink. You want everything bound. Ideal practices would be every page initialed by the person who did the work, did the research, and by a witness. Both of them initialed contemporaneously. The date it was done. The more beautiful your data is, the more you're going to be able to use it later to show that you have really conceived of invention as of that date. If you have slides of gels, I keep repeating because I know you know some biotech, but anybody who does slides of gels, like gels in a biotech experiment, you want to have those attached in a very good manner. Now you're saying, these days somebody's using these paper notebooks, maybe I'm using computerized ways to record all my technical data, your vendors may say. Well, you want to make sure that you're using an appropriate computer system, I'll probably speak better to this, that can indicate that changes have not been made. Because that's what you're going to want to need to show. We actually had a case where we were able to show who had the earliest date of conception because they kept the receipts of the rabbits that they used. They bought rabbits, and they did some experiments on the rabbits, unfortunately for the rabbit, giving his soul to science. But by holding on to the receipts and being good hoarders, they were able to show that they were the first ones to do these experiments on the rabbits because they had a date on the receipt. So and that's what it came down to. And the process in the patent office is called an interference, which is the administrative proceeding in the patent office to show who had the earliest date of conception and reduction to practice. Yes?
Anyway, just one thing, if you are going to still need it, there are notebooks that are directed towards accounting, and you can get them at Staples and they are numbered.
That's
Pages
good point. Number your notebooks. Yes. Date and note. Yes. Number all your notebooks. Exactly. It's good to know that Staples has them. That's an important point. Numbering them.
You need to look for the accounting records.
Yes. And number your boxes. And make sure they stay with you. And that if you fire someone or they leave, the boxes stay with you. And that's also a big place where that came up in a big litigation we had recently. It involved an invention of a lot of graduate students in a lot of different schools was involved. And graduate students often move on after they graduate and leave and go far. And some of them went back to the countries that they came from. And it was a very complex litigation to try to get, well, half of them we could never get a hold of. It was years ago that they had been graduate students in the United States institutions that went back to their own countries. The data was gone. Nobody could find it. It was very difficult. We ended up winning, thank God. But no, that's a good point. And so you say, well, what else could I do as a business? This is key. You have what's called an invention disclosures form. I'm talking about an invention disclosure statement where you write to the patent office about all the different that's a different thing. Disclosure form. Companies have proprietary ones. We as a firm give our clients general ones, but often, like probably every large company has this. It's a form the company creates, and they make sure they get all the data they want. Not only does it list all those key questions about date of conception. Excuse me. When did you conceive this? Who was involved? It lists the people you feel are inventors, so that if they're a collaborative other institutions, maybe you're going to have to work out something. Sometimes these inventors meet each other at conferences. They're from different institutions. They're each responsible for assigning the rights of whatever they invent to their own institution, so there might need to be an inter-institution agreement. It lists that. It lists the best ways that the inventor knows at the current time to make the invention, to use the invention, any publications that might be a problem, any dates to be in mind, the papers they're going to give. So it's all there on these forms. You can see how any company should have that. So when the idea is fresh in the inventor's mind before the fact, they're listing who's involved, what institutions are those people with, when was it made, how is it made, what do they know right now is the best way to make it. And any facts, you want to get that down on paper, and that is a great thing to have. And some companies, depending on the side, they have regular meetings, quarterly, monthly, however long, where everyone goes over these forms. Sometimes they even reward the inventors for how many forms they submit, because it shows they're inventing, that's their job to be inventing for the company, and that they're taking seriously the responsibility to write up their inventions and do what they're supposed to do. They even get rewards for how many disclosures that are usable that they submit. All of those ways that shows the company is taking seriously the regular and periodic audits of potential material that should be considered for patent protection. Any questions on that?
You have a question?
Yes. Yes.
When you go into an interference proceeding, how important are the witness signatures in the lab notebooks?
Very important. Collaboration of the consistent, reliable collaboration, contemporaneous C's, of the information is extremely important. It could make the difference between whether it's deemed to be credible or not, particularly if it's not otherwise, there's other questions about it, like it's on loose paper or something like that. It's key, so you really want that. Yes?
What's the function of the witness?
The witnessing is just proof that, especially that theoretically, the inventor could have his own best interest or her best interest in mind by maybe citing something that they didn't really invent or that someone else is inventing. And a witness is theoretically a collaborative, independent person who isn't getting direct rights from it.
I thought that was often said, read and understood, and I'm often wondering whether someone signing 99 notebook pages a day can possibly understand any of it.
Right, right. It all goes to credibility, and that may be a factor. Who is this person? Is this a person of skill in the art, is the expression they use? Is this a person who understands that type of technology? If nothing else, they can say, I see that that the inventor is actually the person signing it in front of them. They can at least attest that is the human being. But it all goes to credibility, absolutely. And whoever that person is, are they truly independent? Or if there's someone in the company, don't they, in a sense, maybe get some rights anyway? Maybe they're not a completely independent person themselves. It's all just factors that can go into strengthening your case to make the person who's advocating in your behalf years later have an easier time. Yes?
And how often does the second party actually win an interference?
You
Second
mean a
filing
junior
party? Yeah.
It happens. Particularly, yep, it does. I've been involved in ones where the junior party won. And I've been in ones where there was a nucleic acid case, part of the subject matter, and then there was a protein part, and then which was proteins that were made from the nucleic acids, and then there were methods of making the protein. So there were sort of three related inventions, and one side won two of those, and the other side won the other one, because I think they were the side that had isolated the protein, one side, but the other group side had actually sequenced the nucleic acid. So it worked out that way. So that way, in a sense, the baby ended up being split. So it does happen. Yes?
Do you have any initial impressions about how the Senate bill would change documentation processes?
Oh, it's going to be so interesting to see what happens with that Patent Reform Act. At this point, I'm still reading commentary, and it's still really fresh. So I mean, I can't opine too much on it, but theoretically, it could get rid of interference practice. It's going to be replaced. All those patent lawyers who specialize in interference, who might be out of work, who are the people who do this kind of thing, they're all going to get jobs. It's one of the things I do, so it's going to be doing the post-grant opposition work, I think. So in other words, what's going to be another essential component of that legislation, which we do have slides on a little bit later, is this idea of having a post-grant opposition, that a third party can oppose a patent after grant. And that's what a lot of countries do have. So all those people who like to, do administrative, adversarial proceedings on patentability beforehand in the interference process, they'll now all get work doing opposition proceedings after the fact.
Well, actually, I think that the notes are still going to be important for the issue of derivation.
I'm sorry, could you say that again?
I believe that the issue of taking notes and documenting will still have importance for issues of derivation.
Yes, I think that's very true. There's a lot of ways it's important. And in addition, it's still really useful if you want to show, you might get into a debate with the examiner about a number of different issues. One of them being, are you truly enabled? And that data you could submit in what's called a declaration. The inventors could submit a declaration saying, yes, we are truly enabled. It really would work to, say, treat this other tumor, say, even by showing data that was, developed prior to filing the patent application might be very good for that. Another way is sometimes the examiner says, you don't get your I don't think your claims are novel. I think that someone else invented it first. And I have this publication. And this publication talks about a similar subject matter to your subject matter, and therefore I don't think you're entitled to your patent. And you look at it and you show it to your inventors and say, I want to talk to you about ways that we can overcome and get the examiner to allow our case. And the inventors look at it and go, no, ours is different. In my side, at least, I think that it might be, this might even come up more, where our antibody doesn't have that property. I do a lot of work with antibodies. Our antibody doesn't have that property. That antibody, it says, has that particular binding property. My antibody doesn't. Okay, do you have any evidence of that? Yes. Ta-da, and they can show the written records. Now, in some cases, it's been years that research portion of the company is no longer doing that research. I have cases that have effective filing dates of 1994. So what was done then, that's the only research they're going to do on that. They're not doing research on that anymore. They're keeping the patent alive, but they're not doing any more fresh research. We're not working with those antibodies. So that data that they had then, that's what we have. So again, that's yet another reason why those written records will be key. Yes?
You can still swear behind the reference even if we go to first file?
Under 131?
131.
Affidavits?
If it comes first to file, I don't think so. I don't think that's still going to be available.
Well, you're not claiming the same thing, it's somebody's used. It could be a disclosure in a journal article or something like that. The question is whether that's affecting under 103 rather than 102.
It's an interesting question.
Yeah.
I think we could
There's going to be all kinds of interesting questions.
Yeah.
The lawyer's going to have plenty of work to do if this bill gets through.
Maybe it would start, I don't know, let's think. 102A says it's got to be an invention by another. And they show evidence that it's by another. And we could say it's not by another, it's by you. I think that Houston might have something straight shirt headed question before. Yeah.
I was just going to ask, how far upstream do you encourage your clients to fill internal invention disclosure forms out at time of conception or later down the road when they actually reduce it to practice?
Conception. And then if they can supplement it at reduction to practice, they should do that too. Absolutely.
Right. Oftentimes we'll get documents from inventors during or after the invention disclosure meeting. We'll feed it back to the in-house counsel to say, add this to your records. So it's important to do that. The other thing that's useful, so right now with the swearing behind, I've used records such as emails, non-disclosure agreements to show that there was some activity rather than just held internally, that there were some communications to others. You have to show earliest date of conception and diligent reduction of practice. So the date of conception could be easy. The diligent reduction of practice part, those records are really important. And in one case I had, we've gotten a patent in Australia, gotten a patent in China. The US case, the examiner somehow finds this reference, and I look at it, I said, I cannot beat this reference. So I go to the inventor, I said, who are these guys? He said, hey, that's what I told them. So this receiving party took the invention, filed for patent protection, got the issued patent, and now what? Well, we had filed within a year of the publication date of that earlier reference, so we still had the opportunity. The swearing behind was still available as of today, and we grabbed all these documents and said, well, and this guy, he's not good. He's not a good, writer down of notes guy. And so we had emails and the correspondences internally, and there was another guy who had done a few drawings, and it turns out it was enough. Now, one of the other issues is that issued patent, the company who had taken it, there were two guys that my inventor didn't even really know. He said, yeah, there were a couple other guys, that must have been those two. So he didn't really even present to those two specifically, but they must have been in the room, wherever they were. And that company had gone default, and the patent had gotten sold to a third party. The third party says, we're not going to pay the maintenance fee. So one of the options we explored is, could we buy that patent just in case this swearing behind process doesn't work? And the answer was no, it wasn't available. The maintenance fee hadn't been paid. So the only way to do it was to do the swearing behind process, and this happens to be in the area of fuel cells. So there's a fuel cell, and then there's a device that's called a fuel cartridge that produces hydrogen on demand. It actually brought it into size C battery with some sodium borohydride in there and a catalyst, and it produces hydrogen on demand. But so this patent application was to the fuel cartridge side. So at 50% of his business, we had to win. We had about maybe 26 different documents, which were emails and a couple of drawings and non-disclosure agreements and all that, put together a big story, and the patent office says, yeah, you win, that's good. So you can do this. This wasn't opposition, this is just a swearing behind during the renewal examination process.
Why would common ownership after the case help you?
Why
would common ownership after the fact help you?
No, it would be ownership by our client. Our client. So we
If you
swore
bought
behind.
it later, that means that at the time the invention was made, the applications were not co-owned. How can that help you?
We owned it. We got so that our client owned it because we were the inventors. We just had to show.
I understand that you took the other result. I'm looking into what you said as your consideration to buy the patent separately. The thing about it is at the time the invention was made, the two patents, or two applications, whatever it is, were not co-owned. How would that help you if you bought the patent?
If we were to purchase that other patent by the other who was later in time, who was not the inventors, we just bought it outright.
You bought the technology, not in order to...
Bought the patent protection, bought the patent as property, right.
Okay.
So if our process didn't work, at least we had a backup plan, but it wasn't available. So this is one of the issues, like, whatever you got, give it to me, and we'll make up the story. We will be a zealous advocate on your behalf. You got to remember, at the end of the day, clients coming to you because you are a zealous advocate. So that's one of the issues. So we did everything within our means available and did it, and so now the prosecution continues. And now we're only facing the references that we already have overcome in Australia. So these are very interesting issues, as Deirdre said. People don't often think about, but it can turn out to really, really matter.
As a matter of fact, one of my biggest clients let go of a promising inventor who was the first enlisted inventor on a number of their patents, fired him because he just refused to keep good lab records. And the client felt that it was denigrating the value of the client's intellectual property, and that was one of the reasons he'd been hired, was to invent things, and they wanted to get patents. And by his poor record keeping, that was preventing them from doing a good job on that. So he actually fired the inventor, not for lack of being a good inventor, but for lack of keeping good records, because he didn't understand or refused to make sure that the best value possible was gotten from the intellectual property. So it is that important. Okay, determining ownership.
Okay, so assignments. In the U.S., the applicant are the inventors. Internationally, it would often be the person to whom a duty was owed, or the company, but you can also have individuals. But U.S., you would want to get assignments, so some of these these invention disclosure forms, they'll actually include an assignment right in there. So, like, there are some they just put it right in there. And employment agreements might have an IP clause, a section that says you will assign all inventions to the company. So even if the inventor later refuses to sign an assignment to the company, they did so by way of their employment agreement, and we've run into these situations. So we say, all right, well, we'll just record the form that was signed earlier during the employment. You can also have joint ownership, and so if companies collaborate, you can have 2 parties, multiple parties, 3, 4, having rights to the patent, and they don't have to account to the other for the commercial use of that, so they can separately get some licensing fees. So patents can be co-owned, and agreements to consider. Okay, so do you have anything on that?
Sure. One more thing to keep in mind with the joint ownership. If there is 150 claims in the patent, and one of those claims was co-invented by another person who works for another company, and that other inventor has an employment agreement that says that they have to assign any inventions they have to their company, the entire patent is now co-owned by both companies. If that claim is deleted, and if new declarations are filed and the proper forms are filled out to change inventorship to make it accurate and proper, now that other client may no longer be, that other entity may no longer be a co-owner. So what you claim and how you claim it can determine who owns it, because it can determine who is a true inventor of that subject matter that's claimed, and that in turn can lead to determining who is going to be a co-owner. So always keep that in mind. You see when you get a rejection from the Patent Office for obviousness, it always starts out with some form paragraph saying, sort of, we're assuming that the inventorship is still correct. But always keep in mind when you add or cut claims, you may be adding or cutting the inventors in a sense, because the claims that are being presented have to be invented by the people you said are inventors, and that may affect your ownership. In addition to these agreements, you can probably think of others, material transfer agreements, development agreements. On the biotech side, a lot of times they'll make a deal. You can use my biological materials to do your research, and then we'll each take a cut of the profits, assuming that you've had best efforts to develop over the course of the years. Also in litigation, for some reason I'm simultaneously on 3 different settlement agreements between a plaintiff who's brought a case for patent infringement and the defendant who's been accused of patent infringement. There are many, many issues that go into these settlement agreements, and in some cases they involve that the defendant may or may not concede infringement or validity, and the patent owner may say similarly, may or may not concede, may say, I'm withdrawing all claims against the defendant and all my affiliates, against any of their affiliates in exchange for the defendant conceding validity. In one of my cases, they've added in a supplier agreement. Not only are we settling this case, but the plaintiff is going to supply the defendant with some of the drugs in a specific manner, that there'll be a license. And in a way, it's kind of a nice, positive thing. They've worked it out in a way that they're now developing a business deal that should be profitable to both, where the plaintiff is supplying the defendant with a drug as part of the settlement agreement. Something to keep in mind there. You have a lot of things you have to keep in mind when you do a settlement agreement, whether you ultimately want to file that with the court and have it be listed as a consent judgment, whether you don't. And that can actually even have FDA ramifications as well. So keep that in mind as well. It can affect FDA exclusivity for certain drugs. So you have a lot to keep in mind when you do ownership and licensing agreements. And as you know, an assignment, you're giving over the whole bundle of twigs, as they say. Traditionally, it's all your rights, you have nothing left. With an ownership assignment, a license is anything less than that. The individual who's licensing to the other party may be keeping some rights for themselves. It may be exclusive, worldwide, royalty-free to the licensee, but the patent owner may hold on to some rights, or they
And on the due diligence side, if clients say, hey, we're about to invest in this company, a venture capitalists often do this, they say, if we give the money over to this company, and the company should go bankrupt, do we own that intellectual property whereby we can then turn around and at least sell it to recapture some of the value we have invested? So due diligence requires that figure out who owns. Does the company own? Did the founder choose not to assign to the company and hold all the rights? If a merger or sale, right, is the owner of the company said, I didn't assign my rights, so you could have the company, you can't practice because I own the patent. So these are some real issues. So that's why assignments, it's sort of an administrative task, but it's a very important administrative task, just to be sure, because later on the client may have to raise capital and there's no, it hasn't been done. One good example, I remember, it was way back in the beginning when I started practicing. I was in all weekend getting assignments done from this small company, relatively small company. We got the assignments filed. A week or two later, there was a notice in Wall Street Journal saying, small company gets bought up by Cisco for $800 million. So I figured out why I was in all weekend, because they didn't tell me why I was in, but they had to get the assignments in place at the patent office before this sale could be completed. So this is an example. Get the assignments early and often.
And you make a very good point. I was just going over this recently with someone. Now, what is the value of recording your assignment in the patent office? Once the assignment instrument is signed, both the assigning entity assigns the rights to the patent to the other entity. At that point, the assignment is complete. The other entity now has the rights. The rights have been transferred due to the signing of that agreement. So does anybody know, why do we record? What's the point? I'm sorry? Yes, that's exactly right. The only, people get confused about that and they think that recordation is what transfers the rights. No. The rights are transferred by you signing the agreement. Even if you keep it in a file and you put it in a dark drawer and no one ever sees it, it doesn't matter. It's legally done. And you can bring that to court if you ever need to. You're done. What it does to record it, and it's a good idea to do, all that does is it tells bona fide purchasers that they should be on notice that you have the rights to it. So it's important to record your assignments in the patent office so that people, so let's say somebody else, let's say the inventor for some reason assigns to an entity. The entity doesn't record the patent assignment in the patent office, and then the inventor gets fired, the inventor's annoyed, the inventor then sells the invention to someone else. Okay, the other person doesn't have and the other person starts to use it. Well, was not right of the inventor. The inventor did something illegal. The inventor transferred rights they did not have. The inventor was fraudulent. But then what happens with that other entity? That other entity was a bona fide purchaser. They didn't know that anyone else owned the rights. I mean, they might have checked. They might have done the due diligence and gone onto the PTO website. They might have looked at the assignment. They don't see any assignment to anybody else. They figure, I'm good to go. And it was never recorded. That would affect the rights of the true owner of the company from getting damages, etc., from the other company. So it's important to record regularly and to have a nice, clear, clean record. And I would expect that in my due diligence as well. Not just that the assignments be signed, but that they be properly recorded.
And I don't know when to file, so this has to do with bar dates. U.S. currently there's a 1-year grace period. You can publish an invention, and then you have a year within which to file for patent protection. Certain countries, certain foreign countries like countries in Europe, they have an absolute bar of novelty. So if you publish today, tomorrow, and you file for patent protection, it won't help you. It's too late. So you have to be mindful of countries that have grace periods and countries that don't. Canada's 1 year, Australia's 1 year, certain Asian countries are 6 months. You can get those rights, you can get the protection if you file a PCT application designating those countries. So within 6 months, you file a PCT application, and you say, okay, we can now later enter China, Japan, and not worry about that we had published earlier. So those are some real issues. We're constantly, you have to tell inventors, you got to remind them about these grace periods.
Actually, one thing that you should be mindful is that the term disclosure is different from one country to the next. The disclosure in some countries have to be, for example, in England, if you disclose an agricultural invention in an agricultural show, it does not include a disclosure, does not constitute a disclosure. Every country has their own, so an important consideration is find out where the client is interested in, which places the client is interested, to often associate from this country.
Right.
Absolutely, and sometimes when you think you're dead in the water, there's also different exceptions and defenses to these disclosures in different countries as well. But it is really heartbreaking when the client is excited about going into a country and they come to you and you have to tell them it's too late. Another thing that's fortunate, as these business decisions are made along the way, you might have a small startup company with just, they don't have a lot of money and they can't afford to go into all these countries because of the expense of translation costs, et cetera. It can become quite pricey. And then they have a potential investor or licensee, and the licensee says, well, we can't be in Japan, that's really our main market, so we're not gonna, and they come to you and say, okay, we need an application in Japan, and we can't, it's too late. So unfortunately, before the client has that licensee funds, a lot of times, that they would be able to use to go ahead with the examination and translation in some of these countries, they have to sort of guess where they might be getting those licensee funds before they have the license. Because it becomes this chicken and egg thing. They didn't file because they couldn't afford it, but then they had a licensee, now they could afford it, but now it's too late. So it can be a very difficult decision, and sometimes they'll ask, what is the likelihood that we'll get the application in there? And you're trying to do a reasoned estimate of likelihood so that the funds can stretch well across the possible area. Also, people don't always realize what they're doing that can be a disclosure, whether at a trade show or CES in Las Vegas, there's an electronics trade show, something might be divulged in an enabling fashion that could destroy enablement. Biotech side, a conference could be given where two people are speaking, or have a poster session, and the poster, they have enough information that could enable invention that can affect novelty. You want to get your patent application on file as soon as you can after that. Sometimes people will send me abstracts and poster presentations, et cetera, to vet out and take out enough information to make it hopefully not destroying their novelty or anticipating their invention.
Yeah, there's always a low-cost way. File a provisional application.
Yeah.
You'll get what you put in there. It's a little risky, but it's better than nothing. So you know, it's a low-cost option for clients that you always have to be mindful of.
Yeah, and so sometimes it's definitely the safest thing to do. Where to file? Patents have so many different ways that they can confer values and advantages to the client. Again, another decision point where they have to decide how does obtaining intellectual property rights fitting in with their business model, their exit strategy, and ultimate plans. So, are they going to be making it themselves? Are they going to just be keeping other people from making it? Or are they trying to license it or manufacture it? All of those, they have to start really thinking about that and decide where to go. Sometimes they want to go where if they're going to be making it themselves, they want to go into the markets where their customers will be and file there. Where are they manufacturing? That a lot of companies manufacture like in Amsterdam, you might want to file there. Some countries are very pro-plaintiff. Maybe you want to file in those countries if you're going to be planning to enforce and litigate. Where is your evil competitor? Maybe you don't really do a lot of work there, but you really want to sales there, but you want to block them. So maybe you want to be there. Your license agreements. Be careful when you sign a license agreement or you're negotiating a license agreement. I have some cases where we are going into countries where the client will never enforce the patent because of the nature of their technology, and they have to pay all of these fees to all of these countries, like literally like 30, 40, 50 countries. They're never going to do anything in those countries. But that's what the license agreement said. The license agreement said they would use best efforts to file worldwide, and which is good for us, moneymaker for us, because we get some money doing that, but it's not really good for the about unusual patent laws that in certain countries. So keep that in mind too. The license agreement may require entry into certain countries of a patent application. And always keep in mind the value for future investors and desirability to licensees that you're trying to attract. So there's a lot of features and factors that go in, as well as to tie in the last slide, where you can go, and where you have the rights to go. Maybe it's too late in a country that has absolute novelty, which means once it's been divulged, you can't, once a patent application invention, subject matter has been divulged and no application was prior filed, you just can't go into that country at all. And another thing to keep in mind is if you have a 200-page application with a lot of detail and your figures have a lot of detail and you have to do translation fees in each country, that could be expensive. Some countries, some applicants choose to go into English-speaking countries. Canada, they don't have a lot of money and they want to go beyond the U.S. They'll choose Canada, Australia, and England as countries that have a national English language, which will not require translation fees. It can also depend on where the inventors and applicants are from. That can play a role too in their decisions.
And so ultimately, one of the goals is just make sure that the value is there. So trying to raise capital, trying to sell the company, you put the mechanisms in place to make the revenue or sale possible. Okay, so this gets into sort of interesting. On the left here it says what is claimed is. In the old days, you used to put a stake in the ground next to your mine. Hey, this is my mine, I claim it. Well, now it's language that defines inventions. That's what it's claimed, is that the invention is defined by the claims. So the entire patent application is just there to support what you claim is yours, to give notice to potential infringers, to the public, what is no longer publicly available other than with permission of the owner of the patent. So the claims define the invention. The claims have certain scope. There are different claim types: method, apparatus, means plus function. These are all different claims types. There are different claim elements. So within the claim, you'll see all these words, and each one of those could be a claim element. The phrase could be a claim element. Business objectives, you have to think about what kind of claims do I want? Do we want to enforce? Do we want a license? Do we want to get investment value? Do we want broad claims that might be harder to get through the patent office, but in the end, if we get them, we're really going to dominate the market here? Do we get narrow claims through the patent office to just, so we don't have to spend a lot of time trying to obtain patent rights? Or, what's the prior art, right? We have to be mindful that the claims have to define the invention. The claims have to not read on the prior art. And the claims have to be broad enough so that others cannot simply design around the claims. So clients all the time come to us and say, how do I practice, make a product that avoids this claim? And we sit and design around claims of an issued patent. So this is some of the activity that goes on. So, do you have something there?
Yeah. Absolutely. As Mark said, you have to always be thinking, what is the best claims to meet this client's objectives? For example, if your client comes to you and they found a gene that causes cancer, sometimes it's best to file 2 separate patent applications to be licensed to 2 different people, maybe on the same day, with methods of treatment and method in one case, and methods of prevention you might have in one case, and in some cases you might have a method of diagnosis or detection. So what is it that they want to use it for? Do you have claims to how it's made, to elements of making it, and methods to the compositions on the biotech chemical side, and you might have methods of using it, and if it's used in different ways, you might want to claim those in different cases, and it might affect the kind of data that you ask your client to get the supports claims. So you're thinking legally, your legal hat, what do you think you can get? You ask them, what have you published already? What do you have already? What's new? What's novel? What's not obvious? Mark breaks many of my new potential new clients' hearts. I bring Mark in if it's a medical device or something such, and they're all excited and say, wait till you meet Mark, he's going to help you. And Mark listens to this. It's been a minute. It's done. Don't waste your money. Here it is.
Yeah.
We show them how to do some simple searching and show it. And sometimes what we just gently say is, here's ways to search the patent office site, right? And why don't you come back and if you, after you take a little bit of look before you spend a lot of money with us and see what you have that's novel and not obvious. One of the first things I worked on as an associate was, we got or the first things that came to me was a disclosure. It was a composition, a pain reliever, and a sleep inducer. So he said, 7 p.m. So, you know, and of course, if they'd invented that back in the 30s or something, I mean, there was a time when it was novel, but at the time it came to us, they thought it was great. It was great. They had all this evidence and proof that it would work, but it wasn't novel. So, but perhaps there's a particular dosage or route of administration or a protocol that is really unique and unusual, really, really helpful.
And you have to get creative.
Yeah.
You know, how do you distinguish? Is there some other way to look? Could you use an element for not its ordinary function? You know, after KSR, that said, here's the obvious issues. Try to fall within one of those categories that are still strong. Unexpected results, elements for not their you know, usual function. There are many, you know, if you look in the MPP and find that you want to fall, get claims, get that magic language. You'll know when you hear it. It takes several years to really, you know, you start to hear it, but you then know, okay, this is our path. We're going to choose our path. Here are multiple backup plans, and you know, so you start to draft claims with the client. So I think we have here, these are examples. So you know, all of it comes. This is, you know, patent law. This is the sexy part. This is the good stuff. You're in there and you say, well, let's hear about your invention. It may be hard to see, but what you see up top there in figure 1, the client says, well, we have a portal that we can detect metal. Well, okay, well that's too broad, right? I could go through Logan. There's you know, there are metal detectors. So why is it interesting? Well, we do it passively. So using something called a gradiometer, right? It detects deflections in the Earth's magnetic field around metal, right? So it can sense it. Well, that's interesting, but that's still common. Well, what else is still interesting about it? Well, we set up these 3. We use directionality. We use something somewhat akin to beam steering. And eventually you get down to say, okay, well, let's see if we can write it out, define the invention. So you see there, claim 1 of a magnetic screening system comprising an arrangement of gradiometers, each including at least 3 magnetometers. That's the directionality. We arrange them in a particular way. A gradiometer processor in communication with the magnetometers that scales outputs from the magnetometers with unequal weights. That tends to be important. That's what actually allows for that directionality to occur. Combines the outputs to orient the direction of sensitivity of the respective gradiometer toward a volume of interest. So you put a whole group of these up over the portal, and you can see on the right side that with the right directionality, you can actually sense that there's a gun. And at least one arrangement processing communication with the arrangement gradiometers uses the gradiometers in a collective manner to detect a target object. All that defines a portal or some other arrangement of these gradiometers that has 3 radiometers, multiple radiometers, such that it can detect. So that's an example of a claim. That's the language right there that would say, we have something that's different, and that is the claim that issues. So it didn't change from when we filed the application through issuance, which meant we really did think about it, really understood the prior art, and really came up with the language that we could argue before the patent office, and it was successful.
Since it did get rejected at first, did that make you think, oh, we probably could have written it to have a more broad range of protection? Do you ever think, oh, we could have gone more?
Yeah, you know, there are those lines that say, boy, if it didn't get rejected, well, how, you know, maybe you could have gone broader. I think there, in this case, there was one rejection that we had to argue. There was another application in this family where there was no rejection, it went straight through. So the question is, could we have gone broader? And oftentimes, I do try to go with the broadest claim as I can work out with the inventor. So I don't feel like usually I've left any subject matter, any embodiments on the table. So, but there are certainly those cases you look at them and you say, boy, they could have gone way broader. And I've seen them myself. At the time of filing, I feel like we've done pretty well, and then it depends the client. Do they want to try to capture broader subject matter? There are risks associated with doing that, but you know, it's each application is different. You try to find the broadest way to define it. So we have a few other examples here. This is a life sciences, so Deirdre.
Yep, this is a method of treatment of Gaucher disease, which is a terrible disease, absolutely terrible. And what is interesting here, it's a method of treatment, it's a combination treatment, so it's really about the means of administration, again, that makes it special and novel. These patients can be given imiglucerase, which is a kind of enzyme that their body needs more of because it's not storing it properly. So these patients desperately need this particular kind of enzyme so that their bodies can function normally. And I believe there's a number of patents to the modified glucocerebrosidase, so the compound was claimed already. What this is the inventors who are always working to do more to improve the lives of patients who have this disease, is they found out that if you increase the receptors, which is the part of the body that's going to receive the drug, if you do something to increase the number of those receptors, you'll help the patient if you give them that, because they'll be able to receive more of the drug, and the drug will be more effective. That could also theoretically lead to lower toxicity and less side effects in general when we can reduce dosage in a general sense. That's often the case. So it's always where you can, a good idea. I don't know if that was the case here, that they've shown that it reduces toxicity and side effects, but it's always generally a good idea to give less drug when you can. You know, I guess companies makes less, but it makes a healthier person. So this is a method of treating Gaucher disease in a patient in need thereof, language the Patent Office generally does require, comprising administering an effective amount. That's a requirement, because otherwise it could be some small amount that has no operable effect of this steroid, which has the effect of increasing the receptors in the patient, receptors that receive the drug, prior to giving the drug in a fashion that allows more drug to be received by the patient. So this type of drug, this kind of claim, a lot of countries like Europe doesn't really have this type of a claim permissible under their system.
And this is a case at MIT, I think it's a Lincoln Labs. It's a erbium-doped fiber amplifier. And this case, the interesting part is there's a big box on the upper right. It's called the loss in sensitive region. And the inventor discovered that he can put optical elements in there. It's a two-pass amplifier. So the light comes in from the left, polarization maintaining signal input, goes over to a Faraday mirror on the right, rotates. I think it's the 90-degree rotator there. So it goes through this loss in sensitive region twice. He found that he could put any optics in there and negligible effect occurs. So you still get the same great gain, but you can use some optical properties, put it right in that region, and still have great performance. So that we just defined a claim that would cover that loss in sensitive region. So what's interesting about it, loss in sensitive region, turns out there was a laser that had almost the exact same structure as this, and then we had to add to the bottom, and being substantially non-lasing. So by adding that language to the claim during prosecution, we said the laser guys, you know, they're trying to lase, and they don't want to just amplify. There's a whole different mechanism going on, therefore it's not obvious, and that claim got through. So with a slight amendment in the middle, we're able to get this through the Patent Office.
Yeah, this was a fun case to work out together. The first claims Mark did. The second claims that the enzyme storage disease was me. The third one was Mark. But this was one of our opportunities to work together. So it's nice to work in a patent law firm where you have people with different technologies, because you can collaborate. If I do biotech and Mark does engineering, together a medical device is an area that we can work on together, which is fun because you get to learn a lot about the other person's technology and a lot of other things. This was a heart preservation chamber. And the key features here was the heart was on an inclined trough. It was on an angle, and that was important because when you're trying to keep a heart alive to go to the transplant patient, you don't want to have it too vertical because the pressure on the tubes can be very bad. You can't have it too horizontal because then it doesn't have enough internal pressure to keep pumping it alive. It dies if it's too flat. The tubes can come out and it can be bad pressure. It can get damaged can't be too flat, can't be too vertical.
And most of it was to keep just the right amount of tension so that the valves would maintain, you know, the operating status. So that was the idea. So usually to transport a heart, you got to put on ice. It has a limited duration, maybe 4 or 6 hours for transport. This does keep a heart alive for like 24 hours in other organs. So it's an interesting device. This is mechanical, but tied in to physiological. So that's the idea. Medical devices, you don't want to say, here's the device. You really want to tie medical devices into the object on which they are operated. So, you know, this is an example.
The other thing, the thing I remember is most entertaining about this case was that, I think it was a primary reference. One of the main references that was cited against us by the examiner was a paint spreader. That you could put a roller on, it would be a metal box with an angular piece of metal inside that you could take a paint roll to paint your walls of your house and stick it in and roll your paint spreader on it, use it at the right angle, and it would still look the same way, and did everything like that. And I'm like, well, it's nothing like art. And they said, well, you can't define a machine by the heart, because the heart's not part of the machine.
So, yeah, and then the issue is it even analogous art, right? So that's one of the issues on the obvious.
If it's novelty.
Right, if it's novelty, right.
Yeah, this was
Yeah, exactly, right. So there was enough to be able to say, nah, it's not, there shouldn't be a novelty issue. I think it was a combination. That angular of the trough was being used, and so some amendments occurred, and so, you know, eventually we got it through the patent office, but it was relatively challenging, even,
this was a challenging case.
even without that. So simple mechanical challenge. This one has to do with, it uses GPS to determine attitude, roll rate, roll pitch, and yaw. So it can go ahead through use of just two antennas and through some inertial measurement units and figure out what is position. There are military applications, but this particular, the commercial application was to get high gain directional antennas pointing to a satellite, so as you're traveling through some hills, you'll still get good signal reception, so you can watch your favorite TV shows while you're in your car moving around. So, but that's the idea here. But this claim just goes ahead and defines, you know, what that invention is.
This case is it's another method case on the biotech side, and it's about a method of protecting a protein during purification from breaking apart. And it just shows that besides your typical treatment, method of treatment claims, method of prevention, method of diagnosis and detection, some inventions that are very valuable are methods of improving research. And that's what this one is. It's a method of protecting a protein by contacting it with a special kind of protein called an alpha crystalline protein, particularly these types at this particular pH range. And this was good that we got the about language in there, because a lot of times there'll be stickers on how much about is defined and whether there's a definite term or not. So that's just an example of that type of thing. I think this claim was amended to add in the specific proteins for which we had data, the P26, SIC-A, and the alpha A.
Okay, so we went through a series of claims, but now you have to say, well, what are the requirements of the claims to get through the patent office? Utility is important. Patentable subject matter. Some of you may have heard the Bilski case, right? What is patentable subject matter? The standard in the Bilski was tied to a particular machine or apparatus or transform an article into a different state of thing, which is known as the machine of transformation test. The Supreme Court said, well, that's not the only test, so let's go back to the useful, concrete, tangible result also. And we've been making this. The interesting thing is, what, no?
Well,
it might be possible. It's hard, but after the Supreme Court.
The Supreme Court basically said only that it's not the only test.
Right.
They did not say that we should go back to the...
Exactly, but that came back into play.
Well,
my
actually, in my experience, what happens is that the United States Patent Office said, okay, that's the test. Now, if somebody wants to prove otherwise, it's their burden, and good luck.
Absolutely, and that's exactly, I was going to say, that's exactly what the USPTO has done. the CAFC, Court of Appeal for the Federal Circuit, said machine and transformation test. Immediately the Patent Office adopted that standard, even before it was finally heard by the Supreme Court, and they're still applying that today. So we make arguments, right? There's a zealous advocacy thing again. You have to make arguments. Well, it's not the only test, and by the way, it is tied to a particular machine or apparatus. Even if it weren't considered that way, we can still argue. So it comes down to making arguments. Novelty, you have to be novel over all the prior art in single reference. Non-obviousness, single reference, what's commonly known in the art, what the applicant admitted in the background section, the applicant admitted prior art. Think about that, and combinations of references. And the specific, you have to be, have definiteness under 112. So these are all 35 USC, 101, 102, 103, 112. And you have to think about that as you're drafting the claim. So you look at the claim, you say, do we have the right language to define the invention, prevent design around, distinguish over the prior art, meet all these criteria?
Mm-hmm. Right. It has to be, you know, are you going to be able to enable the full scope of your claim? You might be novel for a claim that's very, very broad. You might feel that you're the first one to invent it, but if you only have experimental data or even prophetic data for a very, or prophetic examples for a very narrow scope of the genus of which you are entitled, you may have difficulty. So sometimes it may be a good idea to actually wait a little and get a little bit more data before you file your utility application to make sure you truly are enabled for the full scope or claim more narrowly. So even though the enablement and written description and best mode are requirements of the specification of the claims, when you're drafting your claims, you have to keep in mind what are you really enabled for, and what will you be able to ultimately prove that you can claim.
So that comes down to the description. So descriptions, it's there to support the claims. Your claims define the invention. All the rest of it is just to be sure you can survive through the examination process of the Patent Office and survive through litigation process, saying that we have complied with all the requirements of the Patent Office. We have met enablement, written description, and best mode requirements in the U.S. So it's very important. A lot of that can be gotten from inventors. Sometimes they have data, sometimes they have diagrams. Accept it all, incorporate it all as it makes sense given the claims, and that way you can survive examination and litigation.
Yeah, include more data, even in some cases, include some examples, even if it's not currently what they're using. I know I had a case once where I was going to leave out, I think it was blood as a mode of administration, because it really didn't seem relevant to what they were doing at all. But we included it, and it ended up being the only novel aspect of the invention that they could show that they did something with blood. So you want to have a lot of backup positions in your specification, because as you know, you can't add no matter after you file the original application. So you want to give as many examples and ways things can possibly be used as possible. So you'll have a fallback position if the examiner comes up with a piece of killer prior art, which shows exactly how to do the invention exactly the way your client's doing. It probably is your inventor's own work from the year earlier that they published it, didn't tell you, oh, what do you have left? Well, thank goodness you included this other embodiment, so at least we can claim that. That may have some value to the client. You know, and always put in a lot of for examples. You know, everything should be a for example. You don't want to say anything if you can't avoid it. It's black and white. Like, this is the only way you can do it. This is the invention. This is how it is done. If at all possible, you always want to be saying, here's an example of how it can be done. Here's one embodiment. This is a way it can be done. This is a different way it can be done. You know, these aren't all the examples that there could be. You know, it can at least buy you some support that you won't be as stopped.
I have one case that 30 pages of software code. I don't recommend it. I didn't write the case, but I inherited the case. It turns out there were 3 lines of code that we were able to use to get the patent application through the Patent Office. And it turns out later the client sued you know, somebody using that issued patent. And it was only because there were 3 lines of code that the inventor, I made him come into the office and say, you know, how are we going to beat this problem? He said, oh, no, wait. We do these different things. We do this zooming process. And I said, well, where's that stated? He says, Oh yeah, right here, this line of code, this right here, and you know it because there was you know, the little comments, but you know, usually you wouldn't do it. I don't recommend putting, because you're teaching the others how to write the code and make it too easy for others who come afterwards. But you know, that's an example of, you know, be over-inclusive. If you don't think you're going to use it, just still put it in there. If it can prevent others from designing around, good enough. Yeah.
Just a brief question. Can you have copyright protection for code that's included in a patent?
Yes. Yes. As a matter of fact, common law copyright, as soon as it's put into tangible medium, you have that too. But you know, you're going to register, you're going to make it publicly available. It's I don't recommend it. That's why I wouldn't normally include it, but it was there. We took advantage of it in that case.
Very likely the biggest reason why not to was going to be because there was 102 different ways of achieving the same result. And somebody is going to tell you, I'm not doing it the way you would.
Right.
And that's why code
Right.
is not such a great idea.
Yeah, you can capture what the code teaches and turn it into a patently protectable subject matter. That's really what you want to do.
I'm wondering what strategy you have to deal with the 18-month secret prior art. 18 months from the time something's filed, you don't know what was filed, and yet it will bar you under 102E. There must be some magic secret you've discovered over all these years for dealing with that.
Yeah, there is. There is. Expect the unexpected. Expect it. You know it's out there. You can do your own searches. The inventors could know everything, and all of a sudden the patent office finds something you never expected, either U.S. or Europe. You know, it comes up.
However, a more interesting thing is what new legislation is passing. Currently, if something is available under 102, it's available for 103. The U.S. is unique in that respect. Nobody in the world allows something to be available for that respect, or what we call obviousness, before it is published. If the new legislation is passing by, that is going to still be the case, that the 102 is going to be available for 103, and it puts the U.S. the disadvantage against the whole world.
Unintended consequences.
What?
Unintended consequences. You have to, you know, so how do you deal with it? Just be over-inclusive, expect it. Put in backup positions into your applications, in the specifications, in the claims. Sometimes there's nothing you can do about it. You know, prior art is prior art, but you put enough in this to try to survive the examination process and be valid through a litigation process, because you can be sure that, you know, the limited amount of time the patent office has to do, your defendant will have 10 times those resources to dig up, you know, any other prior that can be used to invalidate your claims. So.
The only, and in one caveat, although as I said, you should put in as much information in both positions as possible. The only caveat, and this is a tricky one, but keep this one in mind too. Your patent, you know, just one going with it. Your patent application can be used as prior art against your later patent application, even if it's in the same line of patents. You file a patent application with the data information you have available to you. Then you file what's called a continuation in part application later on, because now you have more data. For example, in biotech, you found out it treats one kind of cancer. Then, a year later, you find out it treats this other kind of cancer. Maybe it was solid tumors before, now it's a blood cancer. Also, you add in the claim, you add in that you file a continuation in part application, which would be a daughter application, or you can file a standalone application, which is not related either way. But let's say you do it as, it doesn't matter, but let's say you do it as a continuation in application, and you claim the earliest priority date, the effective date of your first patent application, in case there's any intervening prior art, anybody has published something since, you say, I get my earlier date, and now I've added my new example to this, with all this great new data showing how it works for blood, and all the claims in your continuation application, maybe they're related to blood, and it's very different. You're not even having a double patenting issue, so you're cool there. And everything is going smoothly. And the examiner says, your first application, you're claiming priority, you're getting the benefit of priority of that claim. You mentioned blood in that list of possible diseases. So you're obvious, or, you know, over your first case. Okay, but you're not enabled for it. So you're obvious and you're not enabled. So you're screwed both ways. So you're just stuck. So sometimes, under certain circumstances, particularly if you know if more data is being developed to support, say, a different embodiment, you may want to wait in that particular circumstance and not mention that it can be used in court, for example. So in other words, sometimes if you have some laundry list, sometimes it's great, you rely on it, of like all the possible ways it could be used. I'm sure there's exactly analogous example in Versailles, all the different ways it can be used, but you don't really enable it, you're just sort of throwing it in this list so that you can maybe rely on it later on, but you can't really enable it, you can't show it, you don't teach enough about showing how it would specifically work for that thing you listed. Later on, when you do have the data, regardless of whether you filed it as a continuation and part application relying on your earlier date, or whether you filed it as a new application, you've now created horrible art for yourself because you've shown people were contemplated. You did. You contemplated that it could be used in this way. And it can be a very, very big problem to create your own art by throwing in some application that you don't feel you really enabled because it can get you for obviousness. And then they say that makes it obvious, and yet it's not enabled, so you don't get the benefit of the earlier date. Because in order to get that benefit of the earlier date, you have to show that it was voiced in the earlier application. So it's all this very sort of scary sometimes strategic game where you're trying to, you have to do a lot of betting and guessing and gambling on what you feel is the best strategy and the best way before you even know what necessarily what the data will do.
So how do you navigate the process? So just be prepared. So we sort of covered, claim amendments, right? We mentioned that if you're going through the process, your claims are too broad as prior. You have a position to amend the claims. You can do that. There was this Festo case where if you make a narrowing amendment, right? Festo was 95 or so, that you have lost some scope and you are stuck with it because of the doctrine of equivalence. You have narrowed the scope. You have narrowed the doctrine of equivalence. At the time, it was like the Earth was, this was the end of all the whole thing. So, but people realized that you've always had this issue, but that was the Supreme Court case once, maybe twice, but not a big deal. And making remarks on the record, right? You're making arguments. Hey, we're different from that prior because we do this, and you categorize, you make a statement that our invention is this. You may be living with that statement during litigation, and yeah, you got to be. It's as important as what you put into the application in the first instance as what you say about it during the examination process. And this holds true if you make assertions to the Foreign Office. That's going to potentially be narrowing during the course of litigation, so that could be part of the record. Any statements made on the record are going to be potentially damaging to your litigation case later. So as patent prosecutors, when we learn that half, we want to say, how do we keep as many options open for the litigators later, so that design rounds are very difficult, so therefore our litigators can go and enforce the patent later. But you still have to get the application through the patent office, so it's a very delicate balance. You will have to make some statements on the record. So that's part of the process.
Actually, I think just in the last week or two, the CAFC did rule that came out very specifically and stated that prosecution in other countries is not